Restoring judicial fact-finding without synthetic substitutes. This video is the third of a four-part series about how Utah custody cases rely on guardians ad litem and custody evaluators, and what that reliance means for parents, children, and the courts. This video addresses the inevitable follow-up question, which is, if the current system breaks down legally, then what is the alternative? And the answer is not reform, innovation, or experimentation, but ordinary judicial fact-finding tools that already exist in Utah but are often underused, including properly conducted and recorded in-camera judicial interviews of children, developmentally appropriate child testimony, and depositions when necessary. Expert testimony that is confined to assisting the court rather than substituting for it, and recorded interviews and disclosed source material so that conclusions can be tested rather than accepted on faith. Because the problem has never been that courts lack lawful tools to decide custody cases, but that familiarity with substituted processes has displaced confidence in ordinary adjudication. And when testimony is recorded, sources are disclosed, and experts are held to evidentiary standards. The court remains the fact finder. Credibility is assessed where it belongs, and transparency acts as a quality filter that preserves good practice and exposes weak practice.